Welcome to the Binary Agora. I am your host, Alba Rivera Martinez, and building on the interest in the channel that we have for AI overviews as a means to transform search, today we are reviewing a recent ruling issued by the Munich Regional Court relating to the liability assigned to Google as a result of displaying these results at the top of the search page. And to do that, I have with me today Fayrouze Masmi-Dazi. She's the managing partner France for HBSS France, and in her work as a lawyer, she has worked on competition law and EU regulatory law with a focus specifically on the digital sector. And for over 15 years, Fayrouze has assisted and also represented a wide variety of companies, and over the past 8 years has led, I would say, major battles on behalf of online content and also service publishers. So welcome to the Agora, Fayrouze.
Thank you, Alba. Thank you for the invitation.
So getting straight into it, can you provide a brief overview of the Munich Regional Court's ruling and the facts involved?
Yes, well, actually, this ruling came quite as a surprise. So basically, in this case, the court had to rule on a situation involving publishers, online content publishers, which have been somehow accused through AI overview of being connected with fraudulent schemes and, let's say, more generally, dubious business practices. The thing is that what the court tells us and what they have reviewed is that these statements, and I would even say these claims that were provided by AI overview, were not substantiated by any of the search results, actually. The correlation links that were provided in support of that claim or statement did not contain such information, such factual connection between the publishers and, I would say, these practices. So basically, these publishers disputed that and asked the court to order the seize of these practices, claiming that basically AI overview is not only, I would say, a search engine or a host of information, but rather to the extent they summarize, they judge, they rewrite statements, they were actively having a role and a liability as to what they claim, basically. And what is interesting about this judgment is that the court follows these publishers and considers that AIO are not search results. There are lots of developments in the judgments about what is the search engine, does the case law regarding the search engine apply to AIO? And the conclusion is that it doesn't. These are not such results. AIO makes claims, and these claims are not even made in the search results. So the fact that it rewrites and judges the results leads the court to rule that Google, and only Google, controls this claim, controls what AIO produces, and consequently shall be held liable as far as the statements are made. And also the court underlined that Google cannot rely on any exemption based on the DSA, for example, to try to exempt itself from its liability, because it does not, through AIO, it does not only provide or host answers or information, basically.
Thank you for that brief summary. And as you said, the ruling has been described as a landmark moment for AI liability in Europe. And building on your experience, what struck you the most as a lawyer who has really been fighting big tech for years?
Well, first of all, maybe, I don't know if you know it, but actually AI overview is not yet deployed in France. It's the only country where it is not available. So basically in France, we're only seeing search results and not AI overview. So we can really see the difference between the two.
I am wondering, so is that due to the copyright directive transposition and the conflict that Google has had with regards to that? Or is it because of a different reason?
Well, actually, a Google representative just talked about it yesterday in the press, and actually it's linked to the remedies that were undertaken by Google before the French Competition Authority regarding this copyright and neighboring rights directive. So it's definitely because of that, obviously. But coming back to your question, and also to help you know why I mentioned this, I think this is a landmark decision because it confirms and it comforts the idea that when we talk about AI overview, AI mode, and all these tools, ChatGPT would be the same, and any other AI-boosted engine that provide answers based on, or not based on, basically search results, it is not about search, actually. we're talking about something else. This is one major feature of this case. There's a big difference between hosting content and providing an answer to the end consumer. If we put that in perspective with, I would say, the battles you mentioned, there are many battles ongoing, of course, in this respect, and the Commission has started an investigation regarding AIO. The UK CMA has also imposed measures regarding the way AIO gets content, trains itself and grounds its sensors. I think more generally, what it brings forward is that with this kind of tools, we are not talking about traditional search results, and we should not view them, at least from a competition perspective, the same way. When we talk about search results, we talk about vertical relationships and possible harms caused from a vertical perspective. Here, somehow, what the judgment tells is that to the extent they provide answers that they are liable of, they are somehow being really competitors to content providers. And to this extent, they have a liability under civil law, but beyond that, they also have a liability in their horizontal competitive relationship with content providers, to which they cannot exempt themselves based on the traditional tools that they have widely used in this respect. And just to mention, 2 days ago, the Court of Justice of the European Union has ruled on a very important case which comforts the solution adopted by the Munich Regional Court in the Coyote case. In the Coyote case, the Court of Justice really states that a provider of information society services, a platform, cannot exempt itself from its liability for the information it stored and rebroadcast over which it has control. And the court adds that there is such control where the operator determines by means of an algorithm under what conditions, how, and in which order of priority that information is or is not rebroadcast. So it is really, I would say, a confirmation of the solution held by the Munich Regional Court, and even goes deeper into the extent to which Google or any other provider of such responses are to be held liable.
You mentioned and you really drilled down on this fact that the Munich Regional Court does not find that AI overviews really functions as a search engine and as a search function, and it's really an independent content-based processing of I don't know what, so not maybe search results, so something else. Building on what you already said about differentiating these two categories, why is that distinction so salient, and what broader consequences can we also derive from the ruling?
I think one of the important aspects is that we talk a lot about hallucination and Gen AI being able to hallucinate. It's very interesting to read the judgment and see that the court does not talk about hallucination. It talks about untrue factual assertions. And it also talks about the difference between a fact and an opinion. And you will see some developments about what is an opinion. An opinion is a combination of factual and evaluative elements. And that's precisely what content publishers do, press publisher, but generally content publishers do. They have facts and they add evaluative elements. So this is very central because whenever you add evaluative elements, you are in a position of being possibly held liable. So I think this is one of the main aspects that we should take from this judgment, this difference between the facts and evaluative elements and the facts and information and an opinion. And as far as what consequences we can derive from this, well, a lot of consequences. From a competitive perspective, I think these rulings from the Court of Justice and the German court bring us to a point where the question is not only from a competitive perspective, whether or not and how and if it has to be remunerated, the training and the grounding on contents. The outcome in relation to AI overview is something new. It's something that directly competes with publishers. Beyond that, what consequences it has? Training and grounding on publisher content without remunerating it fairly is a problem, of course. But the consumer interface becomes a problem with this judgment and the ruling of the Court of Justice. From a consumer perspective, there is a question of expectation. If I go to Google AI Overview and I get an answer without having to go and click on whatever sources basically that are provided, and in the German court case, we can see that it's not even somehow grounded in search results. result, my view of the topic is biased. And somehow in a qualitative perspective, it poses a problem and a competitive problems beyond a democratic problem when it comes to news publishers, of course. And precisely, I think this is one of the main consequences that we can take from this. We don't have to assess from a competitive perspective only the question of grounding, opt-out from AI overview, or the ability to remunerate publishers for the use of their content. We also have to take into account the consequences. From a B2B perspective, I would say, between Google and publishers, once you don't have traffic coming to your website because of the responses provided by AI overview, for example, of course, there is an impact on your audience, you have an impact on your advertising revenues, you have an impact also on your ability to concur subscribers to get revenue. So there is a big impact on this. If, in addition to that, AI overview provides answers that are not even grounded in truthful sources, then it's even more detrimental somehow from an horizontal perspective, because it's really unfair competition made to content that are grounded, basically. And here I would add a comment. I mean, when you have an information or a fact, there are many ways to evaluate it. And this is basically the principle of pluralism. In France, we have this constitutional principle of pluralism in the media. One fact can be appreciated by 11 medias in a different ways. And this is the conjunction of these views that make somehow someone, a consumer, able to get his own opinion about a fact. And we can even talk about something very simple, like we are in the middle of the World Cup right now, the Football World Cup. So basically the result of a game is a fact, okay? But then a lot of media, sports media, rank the players. They rank their performances, their merits, and the BBC will not rank the same way as L'Équipe, for example, will do in France. And information and opinion is based on that diversity. And where AI overview somehow, in this respect, creates the condition of unfair competition, or from an horizontal perspective, is that it biases this ability to go beyond a fact and not be able even to get the sources, the right sources, the truth sources to substantiate the claims. Of course, as you understand it, I'm very pleased to see that our case law is going in this direction. It's something that was on the lips of a lot of publishers around the world, but somehow that was wished, but barely really expected to come. So it's really important in the discussion and the competition law discussion around these tools.
First of all, don't get me started on the World Cup, because I'm not happy at all as a Spaniard. You're really happy with many, many goals by Mbappe. I'm not so happy. Stemming from this distinction you did between hallucinations and untrue facts, I was wondering if we go further down the line and say, okay, from the perspective of liability, Google can be liable for these results that are untrue, and this is grounded on the German Civil Code, and the Munich Regional Court interpreted the German Civil Code here. But I was wondering, do other EU rules provide for some protection in the damage of a company's reputation, also stemming from, for instance, the DSA or AI Act? And how does that scenario change if we are before a biased result, or we are before an untrue statement, an untrue fact?
Well, that's a big question mark, I would say. It's true that the German ruling is based on German law. If we speak, insofar as I know it, about France, we have very equivalent rules as the German used in this case. And I'm sure in other jurisdictions, there are national rules that provide the same, I would say, direction. At EU level, I think the question is much less, and you pointed it out by saying maybe a combination of the DSA and the AI Act, to the extent the AI Act is applicable and as soon as it will be fully applicable. So we have at EU level a set of rules, and I would even add the Consumer Directive, the GDPR. There are several sets of rules that are either unified when we talk about regulation, or harmonized in terms of the directives that govern several sectorial aspects of the question, that of course may support the same claim, I think. And that's also why I mentioned this ruling of the Court of Justice in the Coyote case, because it was a great chamber ruling. So it has really a weight that goes, I think, beyond the question of law that were raised before the court. And this assertion that the court makes is really something that I think will go as a general principle. And this will certainly support even I would say, claims under competition rules, basically, because whenever you're not exempt from responsibility and whenever your tools, and this tool, for example, differs from the previous case law has treated, it also opens the way to consider it as a different service. So it's true that AI overview has been included, and the German quote underlines it, has been included as a function within the search. But here again, it's very interesting to reflect on that. As you know, France has not AI overview. So we have the search engine as it was. So basically, it's a unilateral decision from Google to put it as a functionality, and the responses in the first place before any link or any sponsored link is presented to the end consumer. So it is, from a competition law perspective, something that should be also very decisive. We have seen over the last years with the emergence and the rise of Gen AI technologies that the question, is it the market trend? Is it the market that makes these tools the new getaway for search in an AI boosted way? Or is it the choice of the dominant player here? And when the dominant player, which is so dominant over the world, chooses one way, it may become the market trend. And that is exactly, for example, what happened when Google announced the Privacy Sandbox project, which it actually did not deploy finally because the CMA has conducted an investigation for several years, market tested the way it was intended to be deployed. And during the transition phase, during this investigation period, all the market players were doing everything they could to adapt themselves to the new Privacy Sandbox tool that Google were intending to deploy. So we might be in the same situation. And what is interesting about this case from the Regional Court of Munich, and in combination with the ruling of the CGU, is that we see that it is a distinct product, a distinct service. And somehow the claim that it is the market that brings us to this trend may be disputed, debated at least. It may really be a unilateral decision from a dominant player, basically.
Going to your perspective as a lawyer and also from the strategic perspective, so the plaintiffs, as you said, are publishers, precisely the community that you represent in your own Google litigation. Do you think that this particular outcome from the Munich Regional Court will embolden other publishers to challenge the actual content of Google's AI surfaces about them? And additionally, you were talking about liability and how different types of legislation and digital rules can be combined in a cluster so as to prompt some of the unilateral behavior that digital companies in the end implement in the market. And I was thinking from the perspective of private enforcement, we can strategically think of claims that are grounded within these clusters of digital rules to provide for these useful outcomes for publishers, or is that something that from the perspective of private enforcement is quite difficult to attain?
Well, there are many questions here. Will it embolden the publisher? I think, of course, the answer is yes, but I think it goes really beyond that. I think it is also a solution that is groundbreaking at worldwide level. The discussion about Gen AI at worldwide level was transparency, accountability, the ability to see the databases, to remunerate publishers for the training and grounding. Now it puts the issue at the center of a question about their liability in themselves as alternatives somehow to content publishers, and the question of their combination with the main getaway in the world to search results on the Google search engine and others somehow. So yes, it will bolden, but it will go beyond, I think, this also regarding consumers. I think consumers are the first concerned by this biased or untrue statements, and beyond consumers, which is ultimately one of the goals of competition law, their welfare. It will definitely bolden these two, I would say, operators, the publishers and the consumers, and possibly open ways to think about GenAI differently also in this respect. As regard the liability, and I would say the private enforcement question, litigation is never easy. Whoever starts litigation knows it. It takes years. It's complicated. The ruling of the Munich court and the ruling of the Court of Justice somehow creates new ways to consider the litigation. So I would rather say that these rulings will support the ability to claim for things, whatever the case is, rather than make it more difficult, actually. I think it's a great step forward because it was the elephant in the room, basically, the responsibility and liability of these AI tools. Then will it in itself bring new cases only based on this? I don't have the answer to this. I don't think so. I think it's an enabler. It's really something that unlocks something that up to now was really locked and unthinkable. It's really interesting that the German publishers have brought it forward and that the judgment has been ordered and that the Court of Justice just 1 week after confirms the direction, basically.
To end the conversation and taking a step back and distancing ourselves from the Munich Regional Court, you have also argued that a competitive European AI ecosystem cannot really emerge without respecting the existing regulatory framework, so DSA, DMA, GDPR. Do you believe that AI should be captured by these instruments, and if so, how? And how do you think that these regulatory instruments would solve differently the same problems that traditional tools have been trying to tackle for some time now?
Well, first of all, I think that competition law is sufficiently flexible to tackle this kind of issues. The question is the timing of the investigation. One of the main interests of the digital regulation in Europe is that we're supposed to tackle things in advance, ex ante. We've seen that this is not as easy as we thought. There is a question of resources, of priorities, and there are so many issues around these digital tools and GenAI tools in particular. And the first thing is to understand the way they work, the way they train themselves, ground answers, provide answers on which platform, on which gateway. So over the last 3 years, I think the authorities, the Commission and the national competition authorities have made a lot of work on this to understand the market. The same way, for example, we did it in advertising, online advertising 10 years ago. So this work, I think, has been done, and we converge on how they work, what is essential to them. Then I think there are two distinct aspects in your question. I will leave it to industrial economists to say whether we need or we don't need to regulate these tools even further through our rules. What I can say from a legal perspective is that I think the DMA, the DSA, they are perfectly able to cover these. And I think one word that is very important, both in the German ruling and the Court of Justice ruling, is that they refer to an algorithm. And an algorithm is not just something in the air, it's something that a company controls. So basically, I think to this extent, when we talk about algorithm, we talk about a mean and not necessarily anything else. And it can be a mean to provide new services. And I think these two judgments combined show that AI overview, and at least the German one, that AI overview is a new service. And to this extent, well, I think competition law is probably a great tool to tackle it. The DSA is probably one other tool to some extent, depending on what plaintiff would want to get, for example. And the DMA, well, it remains to be seen whether the Commission considers that it's part of the core platform services as they are defined, or if we have to amend it, or if we have to create a new core platform service to tackle particularly these kind of tools. So this is an open debate and we'll see. But what is, I think, interesting in this respect is that somehow the problems posed by these new services, such as AI overview, are not new to competition law nor digital regulation. If we talk about DMA, for example, which is much inspired by competition law decisional practice. So it's not something new that we have vertical foreclosure, that we have unfair trading condition imposed on clients or suppliers. And it's not new that it may be combined when we're in a conglomerate with horizontal concerns that we can tackle all together. I think what is new is with these rulings is that we have the whole and the wide scope of perspectives under which these tools can be approached and the problem that they raise at different levels of the value chain, basically.
Thank you so much, Fayrouze, for all of your views on this multifaceted problem that we are trying to tackle from very different sides, from public enforcement, private enforcement, and also, I would say, at different levels, so regional and also national. So thank you so much. And I encourage everyone to also continue supporting Spain in the World Cup. We are going to do better, hopefully. So thank you so much for joining us here in the Agora.
Thank you, Alba. Thank you.
Bye-bye.
Bye.